Sports equipment is used by a variety of athletes with varying skill levels, from professional athletes to children who may be playing catch in their backyard. Just like any other type of product, sports equipment may be defective or cause harm to users. After a person is injured or harmed by a product, the seller, manufacturer, or designer may be found liable under the theory of defective product design, breach of warranty, or strict liability. Imagine that an athlete purchased an expensive stationary bike for his home gym. One day, while the athlete was riding on the bike, the seat post, which supports the entire weight of the rider, broke. The athlete fell backward onto the floor after the seat post failed and broke multiple bones. Before the bike company manufactured the stationary bike, the company discovered the design defect in the seat post. Although the company could have used a safer alternative design, the company didn't use the different seat post design because the company was running behind on its production schedule. Would the athlete likely win a design defect lawsuit against the bike company? Yes. To prove a design defect claim, a party must show that a company knew about the defect, that the company could have used an alternative design that would have been safer, that the alternative design was economically feasible, and that the alternative design served the same purpose as the original design. In this case, the athlete can show that the bike company knew about the design defect and that the company could have used a safer alternative design for the seat post, but it chose not to use the safer design to stay on its production schedule. In design defect cases, there are defenses that defendants can assert, including 1. That the defendant's failure to warn about the defect or the defect itself wasn't the proximate cause of the plaintiff's injury. 2. The plaintiff assumed the increased risk of using the product. 3. The plaintiff was contributorily negligent. 4. The danger caused by the design defect was open and obvious. 5. The defendant issued adequate warnings about the defect. And 6. There wasn't a design defect in the product.